Laws are meant to be followed. This is the common assumption. When a rule is written, carved into stone, or recorded in official documents, we imagine it exists to be obeyed. But this assumption, while logical, does not reflect how legal systems actually functioned through most of human history. Many laws were written with the understanding that they would not be fully enforced. Some existed primarily to demonstrate authority. Others created frameworks for negotiation rather than absolute standards. The gap between what was written and what was practiced was not a failure of the system. It was, in many cases, how the system was designed to work. This pattern appeared across different civilizations and time periods. Roman law included provisions that were rarely applied. Medieval European kingdoms issued edicts that existed more in theory than practice. Imperial Chinese legal codes contained hundreds of regulations that officials selectively enforced or ignored. These were not accidents. They were features of how complex societies managed the gap between written standards and practical governance. Understanding why laws were written to be ignored requires examining what legal systems actually accomplished. They did not simply prohibit or permit behaviors, they created leverage. They established baselines for negotiation. They signaled priorities without necessarily enforcing them absolutely. The written law and the practiced law existed in parallel, and the space between them served important functions. This is not a story about corruption, though corruption existed. It is not about the failure of justice, though justice often failed. It is about how legal systems functioned when rules multiplied beyond what could be consistently applied. And that multiplication happened in every complex society that developed extensive written law. In small communities, rules could be few and clear. Everyone knew them. Everyone could observe whether they were followed. Enforcement was direct and visible. As societies grew larger, this simplicity became impossible. More situations required regulation. More exceptions needed accommodation. More interests demanded consideration. The legal code expanded until no single person could know all of it. At a certain point, comprehensive enforcement became logistically impossible. There were too many rules, too many situations, too many people engaged in too many activities for every law to be actively applied at all times. Authorities had to choose what to enforce, when to enforce it, against whom. These choices were not random. They followed patterns, and those patterns reveal what ignored laws actually accomplished. Laws that were rarely enforced still served purposes. They provided justification when authorities needed it. They created obligations that could be invoked selectively. They established standards that could be applied when convenient and ignored when not. This was not simply inconsistency. It was a form of flexibility that rigid, always enforced law could not provide. Consider markets. Most complex societies had extensive regulations governing trade, weights and measures, quality standards, permitted locations and times, licensing requirements. If all of these were strictly enforced at all times, commerce would have been severely constrained. Instead, officials tolerated most violations most of the time, intervening only when disputes arose or when enforcement served other purposes. The complexity of law created power for those who interpreted it. Judges, magistrates, scribes, legal advisors, these positions gained authority not from enforcing clear rules, but from navigating ambiguous ones. When laws were simple and universally enforced, interpretation mattered little. When laws were complex and selectively enforced, interpretation became everything. The earliest written legal codes appeared in societies that were transitioning from oral tradition to recorded administration. Hammurabi's Code in Babylon, the Laws of Eshnunna, the 12 Tables in Rome. These codes were public, carved in stone, displayed prominently. The assumption is that this publicity meant enforcement, that making laws visible made them operational. But examination of how these societies actually functioned suggests something more complicated. Many provisions in these early codes described idealized standards or maximum penalties rather than practices that were routinely applied. They established what could be done, not what would be done. This distinction matters. A law stating that a certain offense could result in death did not mean it usually did or even that it often did. It meant that penalty was available if authorities chose to apply it. The written standard created a ceiling, not a floor. Everything below that ceiling remained negotiable. This flexibility was not accidental. It allowed rulers to appear decisive and comprehensive in their lawgiving while maintaining practical discretion in actual governance. The code could be pointed to as evidence of order and justice. Specific applications could vary based on circumstances, relationships, and political considerations. Early legal systems thus established a pattern that would persist: written law as framework rather than as direct instruction. The text provided boundaries and reference points. Actual practice occurred within those boundaries but did not mechanically follow from the text. As empires expanded, law multiplied. Each emperor issued edicts, each senate passed decrees, each provincial governor added local regulations, each magistrate interpreted existing rules and created precedents. The accumulation was continuous. Old laws were rarely formally repealed. They simply accumulated, layer upon layer, creating legal codes of extraordinary complexity. By the late Roman Empire, no one could know all of Roman law. Not emperors, not jurists, not anyone. This created an interesting situation. Everyone was technically in violation of something, not because they were criminal, but because the law covered so much that perfect compliance was impossible. You could not engage in trade, marriage, inheritance, construction, or most other activities without technically violating some provision somewhere in the legal code. This universal technical guilt served a function. It meant that authorities always had legal justification if they wanted to act against someone. It also meant that most people, most of the time, were allowed to continue their technical violations without consequence. The system operated on selective inattention. Officials had to ignore most violations because addressing all of them was impossible. The question became which violations to notice. That choice was where real power resided. Medieval European kingdoms followed similar patterns. Royal ordinances multiplied across generations. By the late medieval period, kingdoms had contradictory laws inherited from different eras, overlapping jurisdictions with different rules, and customary practices that diverged from written standards. China's imperial legal codes became famously comprehensive. The Tang Code contained over 500 articles. Later dynasties added more. These codes attempted to cover every possible situation with specific provisions, but China was vast, situations were endless, and local conditions varied enormously. Perfect application was impossible. The multiplication of law thus created a permanent gap between text and practice. This gap was not a failing, it was how the system accommodated reality. Written law established theoretical comprehensiveness. Selective enforcement provided practical flexibility. Some laws were written with minimal expectation of enforcement. They existed to signal priorities, demonstrate authority, or satisfy constituencies. Religious laws often fell into this category. Many societies had legal codes that prohibited blasphemy, heresy, or violations of religious observance. These laws were enforced occasionally, sometimes dramatically. But most of the time, minor violations occurred continuously without consequence. The existence of the law mattered more than its application. It signaled what the society officially valued. It provided justification for action when authorities chose to take it. But day-to-day life involved countless technical violations that everyone, including authorities, effectively ignored. Sumptuary laws provide another example. Many societies prohibited certain classes from wearing particular clothing, consuming specific foods, or displaying wealth in defined ways. Medieval European kingdoms, Imperial China, Tokugawa Japan, all had extensive sumptuary regulations. These laws were rarely enforced consistently. The practical difficulty of monitoring everyone's clothing choices was enormous. The economic disruption from strict enforcement would have been significant. Instead, these laws were applied selectively, often against individuals who had attracted attention for other reasons. The law's existence served purposes even without enforcement. It articulated social hierarchies. It gave authorities tools to use against anyone who became problematic. It created a standard that could be invoked when convenient. Economic regulations followed similar patterns. Price controls, quality standards, trade restrictions, these appeared in legal codes throughout history. Application varied from sporadic to essentially non-existent. Consider price controls. Authorities would decree maximum prices for bread, grain, or other essentials during shortages. The decree signaled concern for the population. It threatened merchants with penalties. But enforcing price controls during actual shortages was extremely difficult and often counterproductive. Merchants who faced below-market prices would hide goods, sell secretly at higher prices, or exit the market entirely. Authorities knew this. The law existed partly to be seen making an effort, partly to provide justification for occasional dramatic enforcement against particularly visible violators. This pattern repeated across civilizations. Ottoman sultans issued price regulations for markets. These were announced publicly, creating the appearance of decisive action. Actual enforcement was inconsistent, focused on maintaining visible order rather than comprehensive price control. The gap between written standard and actual practice was understood by everyone involved. Merchants knew the law existed and knew it would probably not be applied most of the time. Authorities knew merchants knew this. The system functioned on shared understanding that the written rule was aspirational or strategic rather than operational. Selective enforcement was not corruption exactly, though it enabled corruption. It was how legal systems managed the gap between comprehensive codes and limited resources. Authorities had finite time, finite attention, finite capacity to investigate and prosecute. Laws covered infinite situations. Choices had to be made. Which violations to pursue, which to ignore, which to settle informally, which to prosecute formally. These choices followed patterns. Violations by powerful individuals were often overlooked unless they became politically necessary to address. Violations by vulnerable populations were more likely to result in prosecution, unless doing so would create larger problems. Violations that threatened public order received more attention than violations that merely broke technical rules. This created a system where everyone understood that written law was filtered through discretionary application. The law said one thing. What would actually happen depended on who you were, who you knew, what else was happening, and whether authorities had reason to notice. Roman law, for example, prohibited various forms of grain hoarding and price manipulation. These laws existed throughout the Republic and Empire. Enforcement varied dramatically. During normal times, enforcement was minimal. During shortages, enforcement became severe. But even then, it targeted visible violators rather than attempting comprehensive action. The discretion involved was substantial. Two merchants engaging in identical behavior might face entirely different consequences based on factors the law itself did not mention. One might have better connections. One might be foreign rather than citizen. One might have offended someone influential. One might simply have been unlucky in timing. This discretion created what modern analysts would call rule by law rather than rule of law. The law existed, it was applied, but its application depended heavily on factors beyond the text itself. This made the system unpredictable in specific cases while remaining predictable in pattern. Medieval European justice operated similarly. Royal courts, ecclesiastical courts, manorial courts all exercised substantial discretion in what they chose to pursue and how they chose to resolve cases. The same offense might result in execution, mutilation, fine, or nothing, depending on circumstances that had little to do with the written law. This was not necessarily arbitrary. It was responsive to local conditions, political circumstances, and social relationships in ways that mechanical application of written rules could not be. But it meant that knowing the law told you little about what would actually happen in any specific situation. Chinese magistrates faced similar dynamics. The legal code was comprehensive, but magistrates had enormous discretion in how they applied it. They could choose to interpret strictly or flexibly. They could invoke serious penalties or arrange informal settlements. They could emphasize some provisions while effectively ignoring others. This discretion was understood to be part of the magistrate's role. The legal code provided tools. The magistrate decided which tools to use in which situations. This made the magistrate's personal judgment central to how law functioned in practice. As legal codes accumulated over time, they often contained contradictions. Different eras produced different rules. Different authorities issued conflicting provisions. New laws did not always explicitly repeal old ones, creating overlapping and sometimes incompatible requirements. These contradictions required interpretation. Someone had to decide which rule applied, what took precedence, how to reconcile competing provisions. This interpretive function became its own form of power. Legal experts, judges, scribes who understood the archives, these positions gained authority through their ability to navigate contradictory law. They could cite provisions that supported different outcomes. They could identify exceptions, precedents, or competing rules that opened space for the conclusion they or their patrons preferred. This was not necessarily manipulation. The law genuinely was contradictory. Legitimate interpretation required choosing among competing valid authorities. But the fact that legitimate interpretation involved choice meant that legal outcomes depended on interpreters' judgments, not just on written texts. Byzantine law provides clear examples. The Roman legal tradition continued in the Eastern Empire, accumulating 1,000 years of additional imperial edicts, court decisions, and scholarly commentaries. By the medieval period, Byzantine legal experts navigated an enormous, complex, contradictory body of text. The Basilica, a Byzantine legal compilation, attempted to organize this material. But organization did not eliminate contradiction. It made contradiction more visible and gave experts more tools to work with. A skilled legal advisor could find textual support from multiple incompatible positions on most questions. This created space for advocacy and interpretation that went well beyond mechanical application of clear rules. Legal outcomes depended on which texts were cited, how they were interpreted, which were deemed more authoritative, and how apparent contradictions were resolved. All of these involved choices. Islamic legal systems developed similar dynamics through slightly different mechanisms. Multiple schools of jurisprudence offered different interpretations of the same foundational texts. Jurists within schools disagreed on specific questions. This created a rich tradition of legal reasoning that was sophisticated and genuine. But it also meant that legal questions rarely had single definitive answers. A jurist supporting one position could cite authorities. A jurist supporting the opposite position could cite different authorities. Both might be operating within legitimate scholarly traditions. The outcome depended on which interpretation was accepted, which itself might depend on factors beyond pure legal reasoning. Medieval European canon law faced similar issues. Church councils issued decrees over centuries. Popes issued decisions. Local bishops established practices. These sources sometimes conflicted. The Decretum Gratiani attempted to compile and harmonize them, but harmony was not always possible. Legal scholars developed interpretive techniques for managing contradiction. They distinguished between binding rules and advisory guidance. They identified which authorities were more fundamental. They argued about whether later authorities could override earlier ones. All of this created space for interpretation that made legal expertise valuable. The existence of contradiction and the necessity of interpretation meant that knowing the written law was only the beginning. Understanding how it would be interpreted, by whom, in what context, this knowledge mattered more. And that knowledge was not written down. It came from experience, relationships, and understanding of how the system actually operated. These patterns appeared independently in societies with no direct connection. Roman, Chinese, Islamic, medieval European legal systems all developed similar gaps between written law and practiced law. This suggests the patterns emerged from basic features of complex governance rather than cultural transmission. All complex societies faced the same basic challenge. They needed rules to coordinate behavior, resolve disputes, and establish authority. But they also needed flexibility to respond to circumstances the rules did not anticipate. Written law provided one. Selective enforcement and interpretive discretion provided the other. The specific forms varied. Roman legal culture emphasized precedent and jurist opinions. Chinese legal culture emphasized the magistrate's synthetic judgment. Islamic legal culture emphasized scholarly interpretation of foundational texts. Medieval European legal culture emphasized custom and multiple overlapping jurisdictions. But beneath these differences, similar dynamics appeared. Law multiplied beyond comprehensive enforcement. Contradictions required interpretation. Discretion concentrated in those who applied law. Outcomes depended on factors beyond written texts. This similarity across cultures suggests these are not accidents or corruptions, but inherent features of how complex legal systems function. When societies grow beyond the point where simple rules can be comprehensively applied, these patterns emerge. Consider Ottoman legal administration. The Ottomans inherited Islamic legal traditions and adapted them to imperial governance. They developed extensive regulations covering everything from market prices to land tenure to religious communities. These regulations were detailed and often precise. But Ottoman officials also exercised substantial discretion. Local qadis, provincial governors, and the imperial divan all made choices about which regulations to apply strictly, which to apply flexibly, and which to effectively ignore. These choices reflected circumstances, relationships, and political considerations that the written regulations did not explicitly address. The result was a system where written law established frameworks and boundaries, while actual practice varied considerably. A merchant or peasant dealing with Ottoman authorities needed to understand not just what the regulations said, but how officials were likely to apply them in specific circumstances. Chinese legal culture explicitly recognized the role of magistrate discretion. The legal code was comprehensive, but magistrates were expected to exercise judgment in applying it. They could adjust penalties, arrange settlements, or interpret provisions based on circumstances. This discretion was understood as essential to just outcomes rather than as a deviation from proper procedure. The magistrate was supposed to understand the spirit of the law and the specifics of the situation. Mechanical application of written rules without regard to context was considered inferior justice. This created a system where the magistrate's wisdom and judgment were central to how law functioned. Medieval European legal pluralism created discretion through multiple overlapping systems: royal law, feudal custom, urban charters, ecclesiastical law, all coexisted and sometimes conflicted. A dispute might fall under multiple jurisdictions. Which court heard it and which law applied became significant questions that were often negotiable. This complexity meant that legal outcomes depended partly on which legal framework was invoked and accepted. Litigants and their advisors made strategic choices about which courts to use and which legal traditions to cite. The answers were not predetermined by written rules, but emerged from processes of assertion, negotiation, and authoritative decision. All of these systems, Roman, Islamic, Chinese, European, thus developed similar features: written law that was more comprehensive than could be fully enforced, discretion concentrated in those who applied law, outcomes that depended on interpretation, context, and relationships as much as on written texts, flexibility that accommodated circumstances mechanical rule application could not. The pattern was not universal. Some aspects of law, particularly criminal law in serious cases, tended toward more consistent application. But large portions of legal codes functioned more as frameworks and reference points than as directly operational rules. The ambiguity created by complex, selectively enforced law might seem like instability, but in many cases it provided a form of stability that rigid law could not. Societies change continuously. Economic conditions shift. Social relationships evolve. Technologies emerge. Population grows or shrinks. All of these create situations that existing law did not anticipate, or rules that no longer fit circumstances. If law were always strictly enforced exactly as written, these changes would constantly create crises requiring formal legal revision. The process of formally changing law is slow, contentious, and politically difficult. If societies had to formally revise law every time circumstances changed, legal systems would be in constant, visible turmoil. Selective enforcement and interpretive flexibility allowed law to adapt informally. The written text could remain unchanged while actual practice shifted. This preserved the appearance of legal continuity while accommodating real change. Consider inheritance law. Most societies had formal rules about how property transferred on death. These rules reflected assumptions about family structure, gender roles, and economic organization. When those assumptions no longer fit circumstances perfectly, the formal law could remain, while actual practice became more flexible. Officials might interpret provisions generously. Families might arrange transfers differently than formal law specified, but in ways officials tolerated. Exceptions might be carved out for specific situations. All of this happened without formally changing the written law, which preserved legal stability while allowing practical adaptation. Commercial law operated similarly. Rules about contracts, debts, partnerships, and trade developed for specific economic contexts. As commerce evolved, those rules did not always fit new forms of business. Formal revision was slow. Informal accommodation was faster. Merchants and officials developed practices that technically violated or extended written law, but that made commercial sense. These practices became customary. Eventually, they might be formally recognized, but often they simply existed in the gap between written rule and actual practice. This flexibility had costs. It created unpredictability. It enabled favoritism. It concentrated power in those who decided which violations to tolerate. But it also allowed legal systems to function in changing circumstances without constant formal revision. The alternative, rigid, comprehensive enforcement of unchanging written rules, would have required either constant formal legal revision or increasing divergence between law and reality. The first was politically difficult and slow. The second would have delegitimized law entirely. Selective enforcement and interpretive flexibility provided a middle path. The written law maintained authority and continuity. Actual practice adapted to circumstances. The gap between them was where flexibility resided. This was not ideal from the perspective of treating all people equally or providing clear, predictable rules, but it may have been necessary from the perspective of maintaining functional legal systems in complex, changing societies with limited capacity for formal legal revision. The pattern appeared across civilizations and time periods because the underlying challenge was universal. How do you maintain law's authority and stability while accommodating continuous change? Complete rigidity fails. Complete flexibility fails. The actual historical answer was ambiguity. Written rules that were authoritative but not mechanically applied, creating space for adaptation within frameworks of formal continuity. Much of what formal law governed was actually resolved informally. Disputes that could have been litigated were settled through negotiation, mediation, or community pressure. Violations that could have been prosecuted were handled through apology, compensation, or informal sanctions. Formal law provided the background. It established what could happen if informal resolution failed. But most situations never reached formal legal processes. They were resolved in the shadow of law, rather than through its direct application. This pattern was pervasive. Medieval European communities handled most disputes locally through customs and community pressure. Chinese villages resolved conflicts through clan elders and village leaders. Islamic communities often used communal mediation before or instead of qadi courts. Roman patrons interceded for clients to resolve issues without formal litigation. The existence of formal law influenced these informal processes. Parties negotiating a settlement knew what might happen if they went to court. This knowledge shaped what settlements were acceptable. The law created anchors and reference points even when it was not directly applied. But the informal processes were not simply weak versions of formal law. They were different mechanisms that operated according to different logics. Formal law emphasized rules and precedents. Informal resolution emphasized relationships, reputations, and community harmony. A dispute might technically violate written law in ways that could justify severe formal penalties, but informal resolution might arrive at an outcome that restored relationships and maintained community function without imposing those penalties. From a formal legal perspective, this was lenience or inconsistency. From a community function perspective, it was appropriate adaptation. The relationship between formal and informal was not competitive exactly. Formal law provided structure and ultimate recourse. Informal processes provided flexibility and local knowledge. Both were necessary. Neither alone could have handled the volume and variety of disputes and violations that occurred. Authorities often preferred informal resolution for practical reasons. Formal legal processes were expensive, time-consuming, and created winners and losers in ways that could destabilize communities. If most disputes could be resolved informally, that reduced demands on formal systems and maintained better social relations. This created a pattern where written law was comprehensive and formal, but most actual governance occurred through informal mechanisms that operated in the law's shadow. The written law established boundaries and possibilities. Informal processes filled in the vast middle ground. This pattern meant that understanding how law actually functioned required understanding both formal and informal systems and how they interacted. Written codes and formal procedures were important, but not sufficient. The customs, relationships, and informal processes that handled most situations day to day were equally important. This dual system was not articulated in legal theory, which tended to focus on formal law, but it was visible in practice across civilizations and time periods. Formal law existed and mattered. Informal resolution existed and mattered. Both coexisted, creating legal systems that were more complex and more flexible than formal codes alone would suggest. Written law often claimed to apply equally to all. In practice, social status profoundly affected how law was applied. This was not simply corruption, though corruption existed. It was structural to how legal systems operated. Wealthy and powerful individuals had resources that affected every stage of legal process. They had knowledge of law, they had access to legal expertise, they had relationships with officials, they had resources to pursue or defend litigation. These advantages meant that the same written law produced different practical outcomes depending on who was involved. A wealthy merchant accused of trade violations might negotiate a settlement or have charges dropped through intercession. A poor peddler accused of identical violations might face prosecution and penalties. From a formal legal perspective, this was unjust. The law was supposed to apply equally. From a practical perspective, it was nearly inevitable. Legal process at every stage involved human discretion. Those exercising discretion were influenced by the same social hierarchies that operated outside law. Moreover, authorities often saw differential treatment as appropriate. Powerful individuals were useful allies or dangerous enemies. Sanctioning them had costs. Common people had less capacity to cause problems. Sanctioning them was safer. This logic was rarely stated explicitly in legal theory, but it operated in practice. The pattern appeared across civilizations. Roman law theoretically applied to all citizens equally. In practice, senators, wealthy equestrians, and others of high status received different treatment than common citizens. They had advocates, connections, and social position that affected how law was applied to them. Chinese magistrates theoretically applied the legal code uniformly. In practice, local gentry, examination degree holders, and officials' relatives received different consideration than commoners. Their status was recognized formally in some cases and informally in others. Medieval European law explicitly codified different treatment for different estates, clergy, nobility, commoners. But even within these categories, individual status mattered. A wealthy urban merchant received different treatment than a rural peasant, even if both were legally commoners. Islamic law emphasized equality before God and equality in legal treatment, but practice involved significant variation based on status, wealth, and connections. Scholars, merchants with political ties, and others of high social position experienced law differently than poor artisans or rural farmers. The gap between theoretical equality and practical inequality was understood by people living in these systems. They knew that written law was filtered through social reality. They knew that outcomes depended on who you were as much as on what you did. This knowledge shaped behavior and expectations. It also meant that the written law's claim to universal application was partly aspirational and partly strategic. It established a standard that could be invoked when convenient. It provided rhetorical tools for those arguing they had been treated unjustly, but it did not describe how law actually functioned in most cases. This pattern was stable across long periods because it served the interests of those with power while maintaining the appearance of impartial law. The written law could be pointed to as evidence of justice and order. The selective application preserved hierarchies and provided flexibility. Both aspects were useful to authorities. Legal archives grew continuously. Every decision, every edict, every ruling was theoretically part of the legal record. This created enormous bodies of precedent and authority that no individual could fully know. The existence of the archive mattered symbolically. It demonstrated the continuity and comprehensiveness of law. It showed that authority extended backward through time, connecting present decisions to ancient foundations. It provided legitimacy through accumulated tradition. But practically, most of the archive was never consulted. Legal practice drew on familiar authorities and recent precedents. The vast majority of the archived material lay dormant, technically part of the legal system, but functionally irrelevant. This created an interesting dynamic. The comprehensiveness of the archive suggested that law covered everything, but the selectivity of what was actually referenced meant that practice operated on a small subset of what theoretically existed. This subset was not random. It consisted of texts that were useful, well-known, or favored by current authorities. Other equally valid texts were passed over, not because they lacked authority, but because they were less convenient or less familiar. Legal experts gained advantage through knowing the archive better than others. They could identify obscure precedents or forgotten provisions that supported positions they wanted to argue. This expertise was valuable precisely because the archive was too large for common knowledge. Byzantine legal scholars operated in archives containing 1,000 years of imperial law, court decisions, and scholarly commentary. No one could know all of it. Successful scholars knew enough to find useful authorities when needed and to recognize when opponents were citing out of context or from questionable sources. Chinese legal archives contained not just current codes, but historical precedents, classical commentaries, and philosophical texts relevant to legal judgment. Magistrates were supposed to be familiar with this tradition. In practice, they knew portions of it and relied on secretaries and advisors for the rest. European legal traditions split between civil law based on Roman sources and customary law based on local practice. Both generated extensive archives. Universities taught the Roman tradition, local courts applied local custom. Legal practitioners needed to navigate both, drawing on whichever was more advantageous in specific cases. The archive thus functioned as both authority and tool. It legitimized law through its weight and continuity. It provided resources for arguments and interpretations, but it was too large to be comprehensively applied, which meant its application was inherently selective. This selectivity was another source of flexibility. The same archive could support different interpretations and different conclusions. Legal experts could almost always find some authority for the position they wanted to defend. The question was not whether authority existed, but which authority would be deemed more relevant or more persuasive. The growth of the archive also meant that law was always simultaneously stable and changeable. Stable because the written text endured. Changeable because which parts of the written text were invoked and how they were interpreted could shift without formally changing anything. For most people, most of the time, law was background rather than constant presence. They went about their lives, farming, trading, raising families, following customs, without regular interaction with formal legal systems. This did not mean law was irrelevant. It structured possibilities and set boundaries. But within those boundaries, life proceeded according to customs, practical necessities, and social relationships rather than explicit legal rules. A farmer knew generally what was permitted and what was prohibited. He knew he could not murder his neighbor or steal their livestock. He knew he owed certain obligations to his lord or the state. But the details of his daily agricultural work, his family arrangements, his local trade, these operated according to practical knowledge and community custom rather than written law. If disputes arose, they were usually handled locally. Neighbors would mediate, village elders would arbitrate, family patriarchs would decide. These informal mechanisms resolved most conflicts without formal legal intervention. Only when informal resolution failed, or when matters exceeded local capacity, did formal law become directly relevant. A serious crime, a major property dispute, a conflict between communities. These might require magistrates, courts, or officials, but they were exceptions rather than the norm. This pattern meant that written law functioned more as ultimate backstop than as direct regulator of daily life. It was there if needed, but most people, most days, did not need it. They lived within frameworks that law established, but according to customs and practices that law did not directly dictate. The relationship was reciprocal. Law influenced custom over time. Customs influenced how law was interpreted and applied, but neither determined the other completely. Both coexisted, creating layered systems of order and behavior that were more complex than either formal law or informal custom alone would suggest. Understanding this requires recognizing that legal systems were not primarily about telling people what to do in detail. They were about providing frameworks for resolving disputes, punishing serious violations, and establishing authority. Most behavior regulation occurred through non-legal means. This was efficient. Formal legal systems could not have handled the volume of regulation required to direct all behavior. Informal systems handled most situations most of the time. Formal systems provided backup when informal systems failed or when centralized authority needed to assert itself. It also meant that changes in written law often had limited immediate effects on daily life. New edicts were issued, new regulations were proclaimed, but unless enforcement changed significantly, practical behavior might continue largely as before. The written law changed, the practiced law remained more stable. Over long periods, changes in written law could influence customs and practices, but the process was slow, mediated through many layers of interpretation and adaptation. Law shaped life indirectly more than directly, through accumulated influence rather than immediate command. Between a written law and an actual outcome existed multiple layers. Each layer involved human judgment, discretion, and contextual consideration. The written text said something. Officials decided whether to invoke it. They interpreted what it meant in a specific case. They considered who was involved. They assessed what enforcement was practical and what consequences it would create. They chose penalties within whatever range the law allowed. They decided whether to prosecute, negotiate, or ignore. Every one of these steps involved choice. The accumulation of choices meant that the relationship between written law and actual outcome was distant and mediated. The text influenced outcomes, but did not determine them. This layering was not accidental. It was how complex legal systems managed the gap between general rules and specific circumstances. Written rules had to be general to cover many situations, but general rules applied to specific situations required interpretation, adaptation, and judgment. The officials exercising this judgment were constrained by the written law. They could not simply do whatever they wanted. The text established boundaries and reference points. Decisions that deviated too far from written law risked being challenged or overturned. But within these constraints, substantial discretion existed, and that discretion meant that outcomes depended on more than the written text. They depended on who interpreted it, how they interpreted it, what else was happening, and who was involved. This created systems where written law was necessary but not sufficient for predicting outcomes. You needed to know the law, but you also needed to know how it was being applied, by whom, in what context. That knowledge was not written down. It came from experience and observation. The pattern was stable because it worked adequately for those with power, while maintaining the appearance of rule-governed order. The written law demonstrated that authority was based on rules rather than arbitrary whim. The discretion in application preserved flexibility and protected hierarchies. For those without power or knowledge, the system was opaque and often unpredictable. They knew rules existed, but might not know exactly what they were or how they would be applied. This uncertainty was itself a form of control, making people cautious and dependent on those with legal knowledge. Legal systems persisted across generations. Written law accumulated. Institutions continued. The archive grew. This persistence created continuity and legitimacy. But persistence coexisted with adaptation. How law was applied shifted with circumstances. Which provisions were enforced changed based on priorities. Interpretations evolved as new situations arose. The formal structure remained while actual practice adapted. This combination of persistence and adaptation was one of law's most important features. It allowed systems to appear stable and continuous while actually being quite flexible and responsive. A legal code written centuries earlier might still be officially in force. This gave it authority derived from tradition and time. But its actual application in present circumstances might bear limited resemblance to how it was originally applied. The text persisted, the practice evolved. This evolution rarely acknowledged itself explicitly. Officials did not announce that they were changing how law functioned. They claimed to be applying established law faithfully. But through interpretation, selective enforcement, and accumulated precedent, the practical meaning of that law shifted substantially. The pattern allowed legal systems to maintain legitimacy while adapting to changing circumstances. If law changed explicitly and frequently, it would lose authority. If law never changed, it would become irrelevant. The actual historical pattern was implicit change within formal continuity. Understanding this requires recognizing that written legal texts were more stable than legal practice. The text provided anchors and reference points. Practice moved around those anchors, sometimes close, sometimes distant, but always able to claim connection to the written tradition. This was how legal systems survived across centuries of social, economic, and political change. The formal structure persisted, providing continuity. The practical application adapted, providing relevance. The gap between them was where flexibility resided. These patterns did not end with ancient empires. They continued in modified forms through different legal systems and different eras. The basic dynamic remained. Written law multiplied beyond comprehensive enforcement. Some laws existed for appearance or signaling rather than application. Selective enforcement created discretion. Discretion concentrated in those who interpreted and applied law. Outcomes depended on context and relationships as much as on written rules. Modern legal systems have different forms and different rhetoric, but similar gaps between written law and practiced law persist. This is not simply failure or corruption. It is how complex legal systems manage the impossible task of comprehensively regulating complex societies. Understanding this requires abandoning the assumption that law is primarily about obedience. Law is about many things: order, authority, dispute resolution, establishing standards, providing tools, creating frameworks. Many laws were written with the knowledge that they would not be fully obeyed or comprehensively enforced. This was not a problem to be solved, it was how the system functioned. The written law established what could happen. Selective enforcement determined what did happen. Interpretation connected them. This created flexibility that rigid, comprehensive enforcement could not provide. The pattern repeated across civilizations and time periods because it emerged from basic challenges of governance: how to establish order without rigidity, how to maintain authority without constant coercion, how to adapt without appearing changeable. The answer legal systems developed was ambiguity: written rules that mattered but were not mechanically applied, comprehensive codes that were selectively enforced, clear provisions that required interpretation, authority that operated through discretion as much as through rules. This was not ideal. It created unpredictability. It enabled abuse. It concentrated power. But it also created systems that functioned across centuries of change. Systems that could maintain order without perfect enforcement. Systems that could adapt without constant formal revision. The laws that were written to be ignored were not failures. They were part of how complex legal systems actually worked. Understanding this is understanding something fundamental about how humans organized themselves in complex societies. The pattern was quiet, gradual, often invisible to those within it, but it shaped how law functioned for most of human history. And in various forms, it continues.